exceptionally wonderful job on this. I particularly like the witnesses, Eric. He did an excellent job, as did virtually all of the witnesses. Excellent character actors, very believable and compelling. Some of you should consider a career in acting if you may already be in the acting and drama clubs at your school, but really just a wonderful job, exceptional and convincing too. Also, all of the attorneys I thought were excellent as well. I particularly liked your Maggie's ability to, when you had a very likable witness, to just sort of roll with it, and when you do, to just kind of acknowledge it and still develop and retain a rapport with the jury. I think it's really wonderful. I thought some of the technical objections were also excellent, and I loved your closing in particular. It was just, both closings were just wonderful, but I felt it was compelling, and maybe it's because I have my teenage daughter here and I want her to know that it's not okay and you do have free will, and maybe there's a little bit of that there, but I just found it a really good, compelling arguments that resonated with me, and I think that would resonate with the jury, and so I just think you're all exceptional. I hope you all consider a career in law. I'm a partner at a law firm in New York City. I've been there for 27 years and still practicing, mainly because I still have kids, little kids that haven't graduated yet, but it's a rewarding career. I think you all could just have an amazing career in it, and I hope you consider pursuing it.
That said, you're all young, you're all obviously extremely bright. It is not too late to go to med school. I will certainly second what my colleague has said. This was a first-rate production, absolutely. And when you see the scores, when you see my scores, what I want to emphasize is that, perhaps unlike earlier rounds that I've watched, the differentials that you'll see really were almost entirely due to the persuasiveness of the evidence that I was seeing. I was really grading it as a juror, hearing the case and say, okay, did I believe them or did I believe them? Did they make their case despite the cross-examination, or did the cross-examination break my faith in what they were saying? And so really the difference, and I look back at my score to see it, and truth be told, the scores on direct for both sides tended to be stronger than the scores for cross for both sides. So it's not a question of ability, it's just a question of how we're going. So again, things are rolling along. We definitely will be ready for February, I can see that. So in terms of macro refinements, get yourselves to a point where you're comfortable with the documentary evidence. Have it handy, know what it is, know why you're doing it, know the procedures of introducing it, having it looked at, and getting it out to the bench. Just normal stuff that lawyers are going to look for. Just normal professionalism, clean that up. On cross-examination, I think the reason that I graded down on cross, again, both sides, the cross for me needs to be more focused. It's not a discussion. You're not arguing with the witness, you're not chatting with the witness. You've had their affidavits, with the exception of the defendant who can lie his head off, but short of that, every other witness, you know exactly what they could say. You know everything that they have already said in the past in their affidavits or their reports, which is harmful to them. Then you should be able to come in armed with half a dozen questions which you know are bad for their case and which you know they can't get away from. And you just hit them off. 1 through 6, right? So, isn't it a fact? Blah, blah, blah. Again, there was, not only today, but in a lot of cases, you see a little too much reliving testimony that we've already heard, right? And we've just heard. The witness has just said, yes, I'm a bellhop and I've been working there for 26 years. So you don't need to start a cross-examination, and not that you did. I'm just pulling an example out of there, but you wouldn't need to start with, so I understand you're a bellhop and you've been there for 26 years. All right, we just heard that. We know that. And the reason he was saying that on direct was because it's good for him to say that on direct. Why would you want to relive the same evidence that they just brought out on direct Presumably, they brought it out because it helps their case. Why would you want to relive evidence that the other side just brought out on direct? Get right to the bad stuff. Let us know what they're, and again, if at all possible, while you're doing it, you don't want the jury to wonder, okay, I see, that's bad, but where are we going with this and why is it important? Okay? There should never be a question in the jury's mind why it's important. The experts were lovely. Again, just a normal thing with experts when you're preparing your experts. The judge is not necessarily going to understand what they're talking about. The judge doesn't necessarily have any expertise. You know the jury's not going to have any expertise. And again, this is a real world thing, and you know your judges sitting up here are going to look for real world things. Prepare your experts to use short sentences and small words and punchy phrases so that the people on the jury can follow them, so that they understand what they're saying. The experts are very important to your case, but it's absolutely important that they be understood. So when you're preparing your witnesses, who are experts, just make sure that they're going to testify in understandable chunks. Some very, very good points here. They came out in closing argument, would have been a little helpful. The point is made that there doesn't have to be coercion, right? It can still be entrapment without coercion. Very important point. I would have liked to have sat up and noticed that during the testimony. It may have been in there, but it didn't stick with me. It was good to have it. I mean, you absolutely have to have it in closing. Good thing it was there. But at the same time, there was. I'm looking to see if I have my notes. Oh, the timeline. You know, we've got two things going on here. We've got the preponderance of evidence question about the entrapment, but we also have the beyond a reasonable doubt of predisposition. The predisposition case really comes down to the timeline, right? You got to the timeline in the closing. And I sat up and I noticed it in the closing. Yeah, this happened in March, but in February, before they ever met Keenan, he's on the phone saying this, this, and this. It just, I didn't remember it vividly from the testimony. I'm sure it was there, okay? But if it was there, it should have stuck out. You know, there should have been a red flag for the jury and the judge at that point, because that's a very, very important point. You know, it's a curious thing about this, and I'll leave you to your own decisions as to whether or not, if they make the bribe and they weren't entrapped, is that by definition predisposition? You know, I mean, if they can't prove that they were entrapped, that just means that they made the bribe on their own hook. So that is a predisposition. So I don't know that you need a whole big case to prove predisposition, but since it's a beyond a reasonable doubt, it certainly is useful to refer to the timeline. I don't know what else the materials present to you to show predisposition, but as long as you got the timeline, absolutely use it and you know, underline it during the trial. Just a curious thing for the prosecution, constantly restating your appearances every time you stood up. Is that for the benefit of the witness, so you're just introducing yourself, or is that supposed to be for the benefit of the court? Because if it's for the benefit of the court, it's not necessary. We got your appearances in the beginning, and the court reporter knows exactly who you are, and your name will appear in the transcript. So it's just curious.
We got mixed reviews about that. Some judges like it when we announce ourselves every single time. Some judges does it, so we just tried it out, apparently.
Okay. I mean, I didn't find it offensive. I just found it curious.
Yeah. Specifically last round, the judge wanted you to do that so they could understand, like, on the ballot sheet, like, who's doing it.
Okay. So that's a moot, a mock trial judging thing. Yeah, okay. That's fine. I live with that, you know. I suppose actually, a sneaky way to do it would be to put it in the context of introducing yourself to the witness, so you're being cordial, right? You know, because this witness, first of all, they're all sequestered, right? They weren't here for your appearances, they don't know who you are, and you don't have
Okay.
name tags. So it would be perfectly natural to say, doctor, I'm so-and-so, so-and-so, and I'm gonna ask you a few questions. In which case, the judge just got the thing, and you had a reasonable context to put it in. Just a thought. And just lastly, and again, this is just chatting, well, I have 2 seconds to do it. Covington accepted the bribe, right?
Yeah.
If Keenan is just working for the police, Keenan has no idea that Covington's not going to blow the whistle on the whole thing. It's just, I'm not sure how it cuts. This is just something to think about, and whether or not there's anything in the case for the prosecution or the defense as we go forward, whether there's something to be made of it. So you might look at, but sitting here as a juror, I'm sitting here thinking, it's just odd. Because we've had all these machinations, all these meetings, all these suggestions or non-suggestions about bribery, and yet Covington is never in the mix. And a napkin is handed to Covington, right, with 150,000 K on it, or 150K dollars on it, and hands it back. As far as we know from the evidence up till then, that's the first time that Covington has ever been present at any kind of meeting where that was even suggested. And does he know what it is, or she know what it is, and hands it back and then takes it? I don't know if there's anything to make of it, but certainly as a juror sitting here, it's a queer thing, because I can understand the dynamic between these guys. Was it too forceful, wasn't it forceful? Certainly he's there at your elbow during the things, and it's understandable why you did what you did, but still wondering, where does Covington come into all this? Just a thought on the way out. My name is Phil Bramson, by the way. I am an attorney with the law firm of Hiscock and Barkley. We were Hiscock and Barkley until June. Now we are Barkley Damon. It's a large upstate New York firm. Most of their offices are in Syracuse, Buffalo, and Rochester. I have an office in Manhattan with a couple of lawyers. It's a full-service firm. My particular specialty is insurance coverage and insurance coverage litigation. I've been generally a litigator for about 26 years, ever since I got into it.
And I'm Marjorie Glover with Chadbourne Park in New York City.
Chadbourne Park is huge. She's underplaying it. Chadbourne Park is